Good day, Crime Talk aficionados. We have a great show for you today. First, we've been taking a look at the motions currently pending in the Bryan Kohberger matter. Did he confess? Luigi Mangione gets a new attorney in New York, and everybody thinks she's a hotshot. Some real estate tycoons who happen to be brothers have been arrested. Skeletor gets a 100-year sentence. A woman dies trying to defend her store. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps as well. Please go to crimetalksearch.com. Sign up for that background subscription service today. If you do, you're going to be happy that you did. Remember, you can cancel at any time. So if you want to do a search a day, you can do that. If you want to do 5 searches a day, if you want to do 1 search, that's all you need to do. And when you do that, you're going to be able to get all kinds of background information on the person that you're looking for, down to their social media, emails, phone numbers that are registered in their name, criminal history, bankruptcy filings, anything that you may want to find out about a person. And here's the beautiful thing as well. You can get an update on all of searches that you do in the future. They actually update it for you if something changes. So go to crimetalksearch.com. You'll be happy that you did. All right, let's get to it today. First, I've been taking a look at the Bryan Kohberger motions that were filed by the defense back in November. Now, the government just filed their responses, and basically there's not a whole lot there in the government response other than saying, hey, everything is fine. Trust us, judge. Nothing to worry about. But the one motion that I would love to have access to is the motion for the Franks hearing. Now, normally a Franks hearing is saying that there's some sort of false statement that was made with some sort of reckless disregard, and therefore you can have a hearing and you can see if everything after that is basically should be suppressed. All right. And that is the gist of most of the motions as it relates in the Bryan Kohberger matter. All right. First one, motion to suppress and memorandum of support as it relates to the Amazon account. All right. Now, when you go back and you look at this file, there were search warrants to just about everybody under the sun, probably had an app on Bryan Kohberger's phone. But you move to suppress when there's something incriminating. So what's interesting as it relates to the motion to suppress from Amazon is, yes, all the information and the details as it relates to what he had purchased. I wonder what he purchased. Was it perhaps maybe, something we have here on our desk? That's right, the infamous K-bar. Well, of course, they don't articulate what was purchased, but they're looking for basically the information. And what they have said is that all the genealogical information that the government used to search for and find Bryan Kohberger was obtained illegally. And so they're saying that if you suppress the genealogical information that the FBI obtained and created this profile to say, hey, it must be Bryan Kohberger, everything flows from there. So like I said, you don't file a bunch of motions to suppress on information that's completely irrelevant. You file it on something that you want to make go away. So something at Amazon the defense wants to make go away. The gist of the argument is that it was an overly broad warrant, and it was obtained based upon information as it relates to genealogical information, which was obtained illegally. And therefore, guess what? If you take that out, you can't say that Bryan Kohberger was, in fact, the guilty party, and to make that go away. The search of the apartment, same basic argument. The affidavit submitted in support of the application for the search warrant included information that must be excised because it was obtained in violation of the Constitution of the state of Idaho. And all the information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. That's what it's coming down to. Now, if you were to go back and look at videos when this case first started out and we started learning about the genetic genealogy information from this third party, we said, you got to make that DNA go away. Who remembers, raise your hands, who remembers Scott saying, you got to make that DNA go away because that is it. And then, of course, people say, oh, Scott, his DNA could have got there anyway. Oh, it's so plausible. No, it couldn't. And I'm telling you, this is from a defense attorney, all right? I saw a comment I was looking over the weekend. I was like, is this guy even a defense attorney? He sounds very pro-prosecution. Oh, no, I'm definitely a defense attorney. But my job, just like if you were my client, I'd have to tell you the good and the bad and the ugly about a case. You can't just jump on a case and say, these are all the facts. You're going to look like a fool if you don't acknowledge the bad facts. Bad facts, Bryan Kohberger, guess what? His DNA at the scene, allegedly. So let's talk about that. The next one, motion to suppress memorandum as it relates to the AT&T, the phone records. First warrant, right? Same type of situation. A lot of these motions get into these third-party doctrine, as it basically states is like, hey, you don't have a right to suppress these items that these other companies hold for you. You know, like your phone records, you know, your call detail records showing where you are. That they keep that, and if they can get it, you know, basically all these tech companies have been turned into an investigative arm of your local police department, the FBI, and every other agency that needs this information. It's kind of scary. Supreme Court may be whittling that down a little bit with the Carpenter decision, but not enough in my humble opinion. That should be my information, and those companies should not be allowed to turn it over to the police without my knowledge or my ability in which to at least protest that. But that's, like I said, my opinion. Google warrants, right? What could AT&T and Google warrants be? AT&T, phone records, location. Google, location, right? Apple accounts, grand jury. Now, I have to agree, a lot of these search warrants were, in my opinion, overly broad. Now, do I expect from what I've seen this judge who's now on the case to grant any of these motions? No. He seems a stickler for it. He's obviously a very, I wouldn't say pro-prosecution, but let's just say he's very firm on the law and the law as it states right now. But I do believe that some of these search warrants, as it relates to the Bryan Kohberger matter, were in fact general warrants. Motion to suppress the search warrant for the Hyundai in Pennsylvania, where it was seized. Once again, where information was obtained and warrant obtained via violation of the Constitution, it needs to be suppressed. All information gathered was because of the law enforcement's unconstitutional use of the investigative genetic genealogy, and thus nothing in the warrant should remain. And information about the client's location taken from his phone must also be excised due to being gathered by an invalid warrant. The search of the person of Mr. Kohberger upon his arrest, once again, everything because they were obtained by an invalid warrant. Now let's talk specifically, and then let's talk specifically about this motion to suppress, and then we'll talk about the motion to suppress statements post-arrest allegedly made by Bryan Kohberger. All right. Now, this is the motion to suppress the memorandum and support thereof, basically saying that they filed a motion in order suppressing all evidence gathered by law enforcement as a result of the search of Bryan Kohberger's person at the Latah County Jail. Let's just go through the facts as the defense sees that. On December 28th, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Bryan Kohberger via Moscow Police Corporal Payne. On December 29th, the magistrate in Pennsylvania issued a warrant for 119 Lambston Drive, Chestnut Turnpike, Monroe County, the home of Bryan Kohberger's parents. On December 29th, 2022, at 2:22 p.m., the magistrate in the matter signed an arrest warrant for Mr. Kohberger in Latah County. The affidavit warrant was signed by the Moscow Police Department Detective Payne. The basic facts Detective Payne used to support were, at 2:43 on December 29th, a criminal complaint and probable cause order were filed in this matter. At 10 p.m., Pennsylvania SWAT began preparation for the arrest of Mr. Kohberger. Despite days of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15, and despite the fact that days of constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go on runs around his parents' neighborhood, police decided attacking Mr. Kohberger with his parents' home was the best option. And despite the fact that days of constant FBI surveillance showed Mr. Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided attacking Mr. Kohberger within his parents' home was the best option. On December 30th, the Pennsylvania SWAT and federal agents raided Mr. Kohberger's home. Mr. Kohberger was arrested. At 4 p.m. on December 30th, 2023, Pennsylvania State Police filed a criminal complaint against Mr. Kohberger. On January 4th, Kohberger was flown to Latah County. On January 5th, Sergeant Blaker requested a search warrant for Mr. Kohberger's person, relying upon the same facts articulated above for the warrant in Pennsylvania. Later that day, Mr. Kohberger was searched, pictures of his body, his fingerprints, and DNA swab taken by members of the Idaho and federal law enforcement in Latah County. The Fourth Amendment obviously states unambiguously that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly described the place to be searched and the person to be seized. And it must be set forth in an affidavit that there is a fair probability that contraband or evidence of the crime will be found in the particular place. They argue that it is clear that the issuing magistrate himself, if he is to fulfill the constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually in fact draw the inference from the evidence presented to him. It was for that reason that the courts have insisted that full facts from which inferences might be drawn and information necessary to determine their reliability be placed before the issuing magistrate. The defense goes on to argue that Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued there would be no investigation into him without that original constitutional violation. It is not the result of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows, two identifications of little to no value, as previously argued. As the Idaho Supreme Court has explained, while this initial burden in showing a factual nexus between the intelligence and the evidence, the state must show that it would have been discovered anyway. The state cannot make this showing. Without the IGG, there is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garage out front. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. Which goes back to what I said all along, right? You got to make that DNA go away. It's a problem, and the defense is trying to do that, all right? Anyway, trap and trace devices, who he called, who he contacted, basically tracking him down as well. Anyway, then we have the government's response, which is basically everything is fine. But this is the one that I found interesting, ladies and gentlemen. It makes you wonder, did Bryan Kohberger confess? So this is the motion to suppress the Pennsylvania search. They're in Albrightsville, Pennsylvania, and statements made, all right? A lot of the same type of information. It says all information in the affidavit was gathered because of the law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. All right, I get it. Then the defense cites the information that we just talked about, that everything was obtained illegally, and then it says separately, the information gathered via the warrant for Mr. Kohberger's AT&T account and the pen, trap, and trace device warrant should be excised for the reasons set out in those motions to suppress, and all other motions to suppress the impact the warrant language. Then, statement after arrests are either fruit of the poisonous tree from an illegal arrest or should be suppressed as a Miranda violation. Any statements post-arrest of Mr. Kohberger are fruit of the poisonous tree from an unlawful arrest. In addition, statements made as soon as he was placed in zip ties and held at gunpoint by many police officers without a Miranda warning should be suppressed. To protect the Fifth Amendment privileges against compulsory self-incrimination, police must inform individuals of their right to remain silent and their right to counsel, either retained or appointed, before undertaking a custodial interrogation. The requirement for Miranda warnings is triggered by the custodial integration. A person need not be under arrest to be in custody for Miranda purposes. Custodial interrogation means questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of actions in any significant way. Interrogation includes not only express questioning, but also words or actions that the police should know are reasonably likely to elicit an incriminating response. Now, Mr. Kohberger was zip-tied after a no-knock warrant was served. He was zip-tied and his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed with at least two officers in the car. One was seated next to him in the back seat. A reasonable person in Mr. Kohberger's position would have understood himself to be in custody, clearly not free to leave. Now, 2 conversations took place before Mr. Kohberger was Mirandized at the police station. It is clear from the police station video that detectives asked him if he had ever been Mirandized before and said that they needed to go through the formality of Mirandizing him. He said no. No video or audio recordings of the entry into the home and initial arrests have been produced. Video and audio begin with Mr. Kohberger in a police car. In determining whether a person has been subjected to custodial interrogation for purposes of Miranda, courts may also consider the conduct of the officers and the nature and manner of the questioning. The conduct of law enforcement with Mr. Kohberger in the house referred to as small talk when he is being recorded during transport. This cannot be verified because no audio or video is produced. The conduct of the officer in the police car transport cannot be described as an interrogation. However, without a video or audio recording of the in-custody discussions inside the house, the true nature of the statements made in the car are without context. Here comes the good part. All statements made at the police station were post-Miranda. Information in the media right after the arrest and attributable to law enforcement report that Bryan Kohberger redacted, ladies and gentlemen. Redacted right there. Let me read it to you again. All statements made at the police station were post-Miranda. Information in the media right after the arrest and attributable to law enforcement report that Mr. Kohberger blank. Such a statement is not in a police report or in an audio-video recording that can be found in discovery. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. If the conversation with Mr. Kohberger inside the house was custodial in nature, the conduct may warrant suppression of the conversation in the police car during transport. In closing, Kohberger's attorneys state that Mr. Kohberger's requests this court to suppress all evidence obtained by the police via the warrant that permitted them to search the parents' home. As explained above, law enforcement failed to knock and announce before the raiding of the home, and the warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, and finally because the affidavit relied upon evidence gained in violation of the Constitution, all in violation of the Fourth Amendment, Article 1, Section 17. Any statements made by Mr. Kohberger are the fruit of the poisonous tree of the illegal arrest. Some statements may also be excludable under Miranda. So there you go. The government's response, pretty weak, basically saying everything was fine, don't worry about it. Of course, the prosecutor's response is that beginning at page 5 of the instant motion, the defendant asserts that the affidavit submitted in support for the application for the issued search warrant recklessly or intentionally omitted facts. Substantively, this section of the defendant's motion merely refers to the defendant's separate Frank's motion of the argument. By way of preliminary response, the state notes that Idaho clearly states that if a search is conducted pursuant to the warrant, the burden is on the defendant to show that the search was invalid. Idaho recognized the United States Supreme Court analysis holding that great deference is paid to the magistrate's determination for probable cause. As demonstrated by the Pennsylvania search warrant, the searches questioned by the defendant, including the search of the defendant's person, were done pursuant to specific Pennsylvania-issued search warrants based upon the substantial probable cause. As to balance to the defendant's submission, the state respectfully refers the court to and incorporates herein the state's separate response to the defendant's Frank's motion and motion to suppress the investigative genetic genealogy, at the state's separate response to the motions to suppress pen, trap, and trace and AT&T accounts. So therefore, typical government response, everything's okay, trust us, judge, we are the government. Clearly what it shows, and just kind of recap here, the defense attorneys for Mr. Kohberger, just like I did early on, realized that the DNA evidence from the investigative genetic genealogy is a problem for him. They got to make that go away. So they are attacking it. Do trial courts throw a lot of this stuff out? No. This is more of an appellate issue. A lot of this was being written as it relates to, for the appellate courts to decide. But like I said, it is interesting to me where they black out what Mr. Kohberger allegedly said. You would think, did he confess? That's usually what you want to suppress, right? A statement that is bad for you, I'll read it to you again. All statements made at the police station were post-Miranda. Information in the media right after arrest and attributable to law enforcement report that Mr. Kohberger blank. Such a statement is not in a police report or in an audio-video recording that can be found in discovery. If it is a statement that the state seeks to attribute to him at trial, it should be suppressed as a non-Mirandized statement. So there you go, ladies and gentlemen. That's the gist of it. The defense says the investigative genetic genealogy is problematic, and everything that flows from that, if the court finds that the genetic genealogy was obtained illegally and somehow in violation of Bryan Kohberger's constitutional rights, the case completely crumbles and goes away, because it should all be suppressed, because every single warrant, just about every other piece of evidence was obtained because of that. So the question is, obviously we don't have that particular motion because it was filed under seal, but we get the gist of it, that somehow it is a violation of Mr. Kohberger's right, that they created a profile based upon some other family member's genealogy. And then, like I said, everything flows from there. It'll be interesting to see also whether he also is alleged to have confessed. If the state says yes, the stuff that's reported in the press is of no interest to us. It's not in any police reports. We're not going to do that. Otherwise, since that was a motion to suppress, the burden then shifts to the prosecution to prove by clear and convincing evidence that the statements were obtained legally, which means all those people from Pennsylvania get a free trip out to Idaho to appear at the motion to suppress hearing. We'll see, ladies and gentlemen. I hope I broke that down for you. There was a lot of information, tried to condense it all, but that is the gist of it. Next, Luigi Mangione. Well, there's been a fundraiser for Luigi Mangione's legal defense fund, and it is now over $75,000 and actually surpasses the total raise for the family of the University of Idaho murder victims. That's right. Mangione's defense fund on Give, Send, Go has now exceeded the popular GoFundMe fundraiser, collecting money to send to Kaylee Gonsalve's family to Bryan Kohberger's murder trial. Nearly $70,000 has been raised for that process. Now, the GoFundMe terms of service prohibit fundraising for legal defense of violent crimes, including murder. Anyway, Give, Send, Go, meanwhile, has collected over $75,000 for the man accused of shooting the United Healthcare CEO, Brian Thompson. The organization's raising money, says, we are not here to celebrate violence, but we do believe in the constitutional right to fair legal representation. I'm okay with that. The people state that if Mangione does not accept the funds, they will go to other U.S. political prisoners instead. Mangione's attorney, the guy in Pennsylvania, Thomas Dickey, has told the media that he will likely not take the money being offered by the fundraiser for his client. Luigi Mangione has retained Karen Friedman Agnafilo, a high-profile New York attorney, to defend him after he was accused of murdering Brian Thompson, the United Healthcare CEO. Now, Ms. Friedman Agnafilo previously worked as the Manhattan District Attorney's Office, serving as the Chief District Attorney for 7 years before moving into private practice just in 2021. So in private practice, she is just a young pup. As you may recall, Mangione faces second-degree murder charges in New York, as well as firearm charges in Pennsylvania. And like I said, it appears as though the family has retained attorney for him. Now, the attorney representing Mr. Mangione in Pennsylvania, Thomas Dickey, has stated that Mangione plans to contest the extradition to New York, but Manhattan DA, the worst district attorney in the history of America, Alvin Bragg, said there's indications that he may waive his right to fight extradition, stating that the waiver is not complete until the court proceedings, but it was the DA's understanding that it's going to happen. Now, the law firm Agnafilo Trader LLC has confirmed that Karen would represent Luigi Mangione in New York, where he has so far been charged with second-degree murder. Now, the new attorney was the Chief Assistant District Attorney in Manhattan from 2014 to 21. She was a trial division chief from 2010 to 2014. She was general counsel on the criminal justice policy for New York between 2006 and 2010. And she worked as an assistant district attorney from 1992 to 2006. And then yet again in 2010 through 2021. So like I said, she's a newbie as it relates to the private side. Everybody brags how she knows everybody in the courthouse. She's very good. She apparently is a consultant with Law and Order and has her own spot on the CNN, or did, basically. We'll see. It's a lot different prosecuting somebody when all the facts, the good facts, are on your side. It's also a lot different when you don't have a lot of good facts and you're representing the defendant, the most hated man in that courtroom. Now, what is interesting is this firm that she works for, she is not a named partner. There are 3 partners. She is listed as of counsel, which means that she's loosely associated with the firm. She's associated with it, but basically she is kind of doing her own thing. Her husband, Mark, is the one who represents P. Diddy on his case as well. So, ought to be a good Christmas in the Agnafilo household with some big checks coming in, that's for sure. All right, next on the docket, 2 real estate tycoons, well, they got themselves into a little trouble, allegedly. 2 luxury real estate brokers and their brothers have been charged with luring, drugging, and violently raping dozens of women over more than a decade, according to a federal indictment that has been unsealed in Manhattan. Now, state charges were also filed Wednesday in Florida against 2 of the brothers and a third man stemming from the alleged sexual assaults. Now, federal prosecutors allege in New York's indictment that Orrin and Tal Alexander, known for brokering deals on high-end properties in New York and Miami, and sibling Elon Alexander used their wealth and influence to take advantage of women from at least 2010 to 2021. Now, the brothers, who all reside in Miami, used deception, fraud, coercion to allegedly entice victims to travel with them or attend parties or events, often covering flights, hotels, and other expenses. This is all according to the indictment. They also, at times, used the promise of a romantic relationship, the indictment alleges. Now, the women were then allegedly drugged and allegedly raped by one or more of the brothers, as well as other men, before being sent away with concert tickets and other luxury items. Now, the United States attorney, of course, who brought the indictment, says this conduct was heinous, and that's why they're prosecuting it. Now, the brothers, according to the U.S. attorney, typically met their victims on dating apps, through social events, and at bars and nightclubs, but they also used party promoters to source women, according to the U.S. attorney. He added that the women were often provided drugs, including cocaine, psychedelic mushrooms, and GHB, and the brothers even surreptitiously drugged some of the women's drinks, leaving them physically impaired and unable to fight back or escape from the sexual assaults, the prosecutors allege. In some instances, the defendants physically restrained and held down their victims during the alleged rapes and sexual assaults and ignored screams and explicit requests to stop. Now, in the Florida cases, state prosecutors describe one incident in December of 2016 as a gang rape of a woman who said she was invited to a barbecue at Elon Alexander's Miami Beach apartment, only to discover no one was there except for Elon, his brother Orrin, and another relative, Ohad, fisherman, who remains at large. Now, the woman, who's not named, said she was led into a bedroom where fishermen held her down, and the brothers argued over who would her first, as she pled with them not to assault her. That's according to the state's attorney there in Florida. The second incident goes back to October of 2017, involved a woman who said Orrin Alexander sexually assaulted her at the apartment after drinking a glass of wine that left her feeling weak and unable to control her body, according to prosecutors in their complaint and information. And they said the third incident happened back in October of 2021 and involved a woman who said Orrin Alexander assaulted her after going back to his residence with friends following dinner. Now, the United States attorney once again said the 3 brothers were arrested in Florida on Wednesday and will appear in Miami federal court before being brought to New York. The United States attorney declined to say if other charges would be brought, but they said they would if more victims came forward. Now, lawyers for the brothers denied the charges, which include one count of engaging in sex trafficking conspiracy for each sibling. Orrin Alexander is innocent. His attorney wrote in an email, "The evidence will show that neither he nor his brothers ever committed a crime. My clients will be entering a not guilty plea and dealing with these charges in the appropriate forum, the courtroom." A lawyer for Tal Alexander declined to comment. The elder brother appeared in Miami federal court Wednesday with a detention hearing for Friday, and the prosecutors argue he's a danger to the community and that he is a flight risk. The two other brothers are in state custody and are expected to appear in court later in the week. Now, once again, like any good criminal allegation of sexual assault, guess what? There is a pending civil case. That's right. So representatives for a number of the women who filed lawsuits earlier this year claiming the brothers violently raped them welcome the charges. We're glad to hear that there will be finally some measure of accountability for the Alexander brothers and justice for their many victims, said the attorney representing the victims. "We applaud all of the survivors who have had the strength and courage to speak up about the unimaginable experience after years of pain and suffering." Now, the brothers, Tal and Orrin Alexander, first worked as a team under a real estate giant, Douglas Elliman, listing properties for Kim Kardashian and Kanye West, Liam Gallagher, and Lindsay Lohan. In 2022, they started their own company called Official. Alon Alexander, who is Orrin's twin brother, attended law school, enjoyed the family's private security business as well. I don't know anymore with these allegations, ladies and gentlemen. Obviously, serious stuff, and if truly these women have been sexually assaulted, without their consent, then these brothers are in serious trouble. We're going to give them the presumption of innocence like we do for anyone who's been accused of a crime that has not been found guilty by a jury of their peers or pled guilty. Only then does that presumption of innocence go away. As a defense attorney, I'm big on the presumption of innocence. It troubles me, though, when there's always a civil suit. I get it. When there's people that have money, they go after them. From the defense side, it's always good that the victims file a lawsuit because they look like they are always about the money, looking for a payday, so to speak. It's much better if the civil suits wait until after there is a conviction, and then it's basically a slam dunk to do that. If you've been convicted beyond a reasonable doubt, what are you going to say at a civil trial, right? It's going to be tough. Only ones that usually win those are like, I don't know, OJ, win in the criminal side and lose on the civil side. So it's much lower standard of proof. But like I said, we'll give everybody the presumption of innocence. We'll see how this turns out. Be curious if the brothers, in fact, ultimately do get detained in the federal system. That's a very serious allegation. And given that they have means in which to flee the country, hey, if it's detention is good enough for P. Diddy, probably good enough for these two brothers as well. Next, Skeletor gets 100 years. That's right. The Texas man with some distinctive facial tattoos, skull face tattoos, was sentenced to 100 years in prison for an 11-hour shooting rampage targeting motorists on freeways and roads in 2 states that killed a man and wounded several others. Please meet Skeletor, a.k.a. Christopher McDonald. He learned his fate last Friday in the death of Kevin Mendiola, who was only 22. Now, Mr. McDonald pled guilty, but mentally ill back in October on charges of first-degree murder with a deadly weapon, conspiracy to commit murder, and discharge of a firearm at or into an occupied vehicle. Both he and his brother and his brother's then wife were indicted in connection with their 2020 Thanksgiving Day shooting spree that began in Nevada and ended in Arizona, where the defendants were apprehended when the car they were in rolled over. In a written statement, Mr. McConnell took responsibility, saying, quote, "I take full responsibility for my own wrongdoings, and I appreciate the court for administering justice," end quote. His public defender said his client was a troubled person. He asked the court to consider a sentence between 21 and 52 years in prison, but the prosecutors asked for the maximum, saying that this was a heinous and random nature of these crimes that threatened many unsuspecting citizens in the community. And like I said, the judge whacked him and gave him 100 years, ladies and gentlemen. Unbelievable. All right, I want you to listen to this story and then take a look at the arrogance in our dumb criminal of the day, okay? Just to give you a flavor for this. So a Florida mom and business owner was killed while trying to stop shoplifters at her beauty supply store leaving behind 2 daughters and a husband. So at least 3 suspects, who all still remain at large, entered the store, and one drove the getaway car. One of the suspects got into the car with the items stolen, while the third suspect was left on foot. So Kim Eilson was taken to the hospital after being hit by the vehicle, and ultimately she passed away because of her injuries. Now, Kim's husband said the store had already been experiencing a reoccurring shoplifting problem, but a neighboring business owner said that at this time the victim had finally had enough and decided to take actions by chasing the suspects. So when they chased after her because they were stealing her stuff, they run her over, ladies and gentlemen. It's her stuff. And I can hear the people now, oh, don't go after the stuff. It's frustrating. I can tell you, I've got a case very similar to this right now where my client's charged with attempted murder. When he goes outside, because these guys came in, stole all the stuff, they shoot back. They shoot at my guy. My guy shoots him, and they charge my client. Unbelievable. Unbelievable. I mean, these store owners operate on very thin margins. They work it themselves because they can't afford to hire employees. It's dangerous work, and to have somebody come in and take your stuff on top of that, it's just insult to injury, ladies and gentlemen. So remember that when we have our dumb criminal of the day, because I think it's appalling what's taking place. Next on the docket, though, let's get to this day in legal history. On December 16th, 1773, a group of American colonists known as the Sons of Liberty boarded an East India Company ship carrying the tea disguised as Native Americans on December 16, 1773, throwing the cargo overboard in protest of the British Parliament's taxes on tea imported by Americans. The protest would result in 5 acts of Parliament known as the Intolerable Acts, including the Boston Port Act, which closed Boston Harbor to all ships. So there you have it, ladies and gentlemen. The Boston Tea Party went down today, 1773. So there you go, ladies and gentlemen. The Boston Tea Party, this date, 1773, must have been a little chilly in Boston that day. Now, this actually happened yesterday, December 15th, but I think it's pretty important. But following ratification by the state of Virginia, the first 10 amendments to the United States Constitution, known collectively as the Bill of Rights, became law of the land in 1789. Now, in September 1789, the first Congress of the United States approved 12 amendments to the U.S. Constitution and sent them to the state for ratification. The amendments were designed to protect the basic rights of U.S. citizens, guaranteeing the freedom of speech, press, assembly, exercise of religion, the right to fair legal proceedings, the right to bear arms as well. That power, not delegated to the federal government, would be reserved for the states and the people. It also included that all powers not specifically delegated to the federal government in the Constitution would be reserved for the states and the people. Now, influenced by the English Bill of Rights of 1689, the Bill of Rights was also drawn from Virginia's Declaration of Rights, drafted by George Mason in 1776. Now, Mason, a native Virginian, was a lifelong champion of individual liberties, and in 1787, he attended the Constitutional Convention and criticized the final document for lacking constitutional protections of basic political rights. In the following ratification struggle, Mason and the other critics agreed to support the Constitution in exchange for assurances that their amendments would be passed immediately. So on December 15th, 1791, Virginia became the 10th of the 14 states to approve 10 of the 12 amendments, thus giving the Bill of Rights the majority of the states' ratification necessary to make it legal. Of the 2 amendments not ratified, the first concerning the population system of representation, while the second prohibited laws varying the payment of congressional members from taking effect until the election intervened. The first of those 2 amendments were never ratified, while the second was finally ratified 200 years later in 1992. So, big weekend for sure, ladies and gentlemen. Bill of Rights, gotta love it. Pocket Constitution, everybody should have one. Not that long, shouldn't take you long to read it. And one more, this day in legal history, on December 16th, 1994, Suzanne Smith was indicted. Yes, she drowned her 2 sons in South Carolina, was formally charged with murder after her initial false claims unraveled. And if you've been following CrimeTalk, you know, just, I don't know, last month or so, she was denied parole after serving 30 years in prison. So she'll get to try again later. All right, let's get to our dumb criminal of the day. And what I'm talking about, you know, the store owner, take a look at this video. These thieves threatened to call the cops on the store security people or the employees there because they were attempting to stop them from stealing. Take a look at that, ladies and gentlemen. Unbelievable. This lady actually truly believes that she has a right to steal everything and that you can't touch her. Now, unfortunately, that's just wrong. So imagine how Miss Kim Ilsen felt when she's running a small mom and pop store and people are coming in and just taking stuff out of her store without paying for it. This looks like it's a Walgreens, but it affects everybody, ladies and gentlemen. That's why I think, you know, you should be able to use deadly force when protecting your property. I would say anything over $1. How does that sound? Okay, maybe 100. Maybe 100.